Good evening, everyone. It is quite late over here in the UK, but we have had Jed Wallace's response to Blake Lively has been filed, so I'm going to go through that now. This has come from Chip Babcock, so I'm really excited. Let's go. Okay, plaintiff's response to defendant's motion for costs and attorney's fees. Plaintiffs Jed Wallace and Street Relations submit this response to defendant Blake Lively's motion for costs and attorney's fees. Unbelievably, Lively is once again back for relief from a Texas court. This time she twists the court's determination that it lacked personal jurisdiction over the claims against her as a decision on the merits of one of her affirmative defenses. This, she says, entitles her to a staggering $800,000 in fees or more, plus court costs, under a wishful reading of a strictly procedural California statute that does not apply in federal court, but even if it did, would not give her the substantive relief she wants. So, we got off to a great start there. I'm going to read the footnotes actually with this one. As explained below, Lively is not entitled to any fees, but plaintiffs reserve the right to challenge on some future date whether the stunning amount was reasonable and necessary otherwise. Oh, I feel like I've waited all my life for this. Lively's request to make California procedural law apply here is part of an ambitious plan to have plaintiffs pay her for a lawsuit prompted by her publication to the national media that plaintiffs, among other things, sexually harassed and retaliated against her, though they've never met her or been in the same room with her, and breached a contract with her, though they've never had a contract with her. As we show again, Lively had no reasonable basis to make these allegations about plaintiffs to the California Civil Rights Division, the media, or anyone else, anywhere else, and I entirely agree with this. I cannot overstate how much I agree with that. And even if she did, the Fifth Circuit rejects such procedural relief in federal court, as does the unanimous United States Supreme Court in Burke. To get her desired result, Lively works backwards from the answer she wants, performing a surface-level conflict of law analysis that ignores where the injuries to plaintiffs occurred in Texas and the interests of her home state, New York, before concluding that California law applies. Lively's reason is as obvious as it is self-serving. Neither Texas nor New York have the same procedural statutory scheme that would allow her to recover the hundreds of thousands of dollars she seeks for filing a motion to dismiss. But even if California law applies, Lively is not a prevailing defendant. The court has not determined, as Lively says, that plaintiffs' claims were meritless. They were not. Instead, the court told us that it did not reach the merits of any defense. Nor could it. At the pleading stage, a court is limited to making findings of fact related to jurisdictional matters on a motion to dismiss. Even then, it only resolves facts in favour of the parties that invoke the court's jurisdiction. Plaintiffs, not the ones seeking dismissal. Lively. Lively asks the court to conclude that her statements were privileged under 47.1, while apparently asking the court to disregard plaintiffs' well-pleaded allegations of malice that defeat that privilege. She cannot do this at the motion to dismiss stage. I do think that's right. this is what I said in my video earlier, like, you're not getting, like, it's a conditional privilege, which is, reliant on the fact on you having a good basis for believing that you have been sexually harassed and, making the statements that without malice. And that has to be proven with facts and evidence. It cannot, I don't see how it could be proven at motion to dismiss. So she cannot do this at the motion to dismiss stage. This is true under Fifth Circuit law regarding motions to dismiss in federal court, and it is true under California law on motions to dismiss in California reviewing Section 47.1 and Section 47, which Lively says controls the day. Lively put us in this procedural posture. She cannot now avoid the effects of that decision, much less seek to benefit from it through a novel reading of the law. In any event, the case is not over. Whether by plaintiff's appeal pending in the Fifth Circuit or by plaintiff's right to replead the same defamation claims against Lively elsewhere. Because she was, his claims were dismissed, but they were dismissed without prejudice, so, he can actually replead them. That means Lively hardly successfully defended herself, such that she is entitled to nearly $1 million in fees and court costs. Right, sorry, I'm just checking the footnotes. The great irony of Lively's motion is that it forces plaintiffs to spend substantial time and resources responding to point after point made in her motion, despite the motion's substantial flaws from end to end. In the process, Lively turns the true goal of Section 47.1, a foreign statute with noble aims, on its head while refusing to acknowledge the serious consequences of her defamatory conduct. The motion should be denied. Oh, I love this. Okay, facts and procedural history. There's another footnote. Plaintiffs incorporate by reference the allegations in the first amended complaint for completeness, but focus on the relevant facts and procedural history below. Plaintiffs sued Lively for defaming them when she published to the press an employment complaint and an attached draft legal complaint she filed with the California Civil Rights Division. The CRD complaint named the Wallace parties as respondents and alleged they had engaged in conduct including sexual harassment, retaliation, failure to investigate, prevent and/or remedy harassment, and aiding and abetting harassment and retaliation. The draft complaint identified the Wallace parties as defendants and alleged claims ranging from sexual harassment to breach of contract. The CRD and draft complaints were not available online or otherwise available to the public when filed, absent a written request for public information. Yet, a reporter sent Wallace an urgent email the same day for comment, with the reporter stating she had learned that Miss Lively filed a legal complaint against you, alleging sexual harassment, retaliation, among other claims. By early the next morning, the draft complaint was posted on the newspaper's website under the banner, "Read the complaint." 10 days later, Lively filed an actual lawsuit in the Southern District of New York. Notably, the document filed in federal court, unlike the CRD and draft complaints, did not name Wallace or Street as defendants. 3 weeks after Lively filed suit in New York and over a month after Lively accused plaintiffs of sexually harassing her, among other things, in her publications to the media, Lively filed a Rule 202 petition against Wallace in Hays County, Texas. The Texas lawsuit conceded that Lively had no facts to support her publications about plaintiffs. She needed to investigate the scope of Mr. Wallace's conduct, and she lacked the critical evidence relevant to petitioners' potential claims, the specifics of the conduct by Mr. Wallace. Plaintiffs then brought this action for defamation and defamation per se, to hold Lively accountable for publicizing that plaintiffs had sexually harassed her, among other things, though they had never met. For example, Lively knew she had never met plaintiffs, meaning she knew they could not possibly have sexually harassed her despite what she said in her CRD and draft complaints. She also knew that she did not have a contract with plaintiffs, meaning she knew that they could not breach some non-existent contract either. Plaintiffs alleged in great detail this absence of knowledge and alleged that Lively committed her defamatory acts with malice. Lively later dismissed her Texas lawsuit and added Wallace and Street to her litigation in New York. The footnote: plaintiffs were dismissed from Lively's New York litigation twice and have been non-parties to that lawsuit since November 5th, 2025. And then they go on, the remaining parties to that case announced a settlement on May 4th, 2026. Great, so he has got that in there. Plaintiffs then amended this action to add factual basis for defamation based on Lively's actions in Texas. Lively moved to dismiss, challenging venue, personal jurisdiction, and the sufficiency of plaintiffs' pleadings under Rule 12b-6. The court explained that it must first address jurisdictional matters, and if jurisdiction is lacking, then the court will not reach the merits. The court ultimately determined that plaintiff's pleadings did not establish that defendant is subject to this court's personal jurisdiction and confirmed that it need not address defendant's other bases for dismissal. The court dismissed plaintiff's claims against Lively without prejudice to refile. Plaintiffs appealed that order to the Fifth Circuit on December 12, 2025. Okay, arguments and authorities. This California procedural law is inapplicable in federal court. California Civil Code Section 47.1A is not procedural. Is procedural, not substantive, and inapplicable here. In diversity actions like this one, state substantive law applies, but state procedural law yields to the applicable federal rules. Considering a state anti-SLAPP statute that included mandatory fee shifting to the prevailing defendant, the Fifth Circuit determined that the statute does not apply to diversity cases in federal court. Lively herself analogizes California Civil Code Section 47.1A to California's anti-SLAPP laws. Taking her at her word, Section 47.1A is a similar procedural state law that is inapplicable here. The motion should be denied for this threshold reason alone. Similarly, the Supreme Court recently decided Burke, which addressed a state statute about pleading requirements for medical malpractice suits. Because that procedural statute conflicted with the pleading requirements of Rule 8, the Supreme Court held that the state procedural law must yield to the federal rules. So too here, Lively's request to determine her privilege defense under California Civil Code Section 47.1A conflicts with the plain meaning of Rule 12b-6, which limits the courts to making jurisdictional findings of fact in deciding motions to dismiss for lack of personal jurisdiction. Thus, the California procedural law must yield. The motion should be denied. Even if this California law were substantive, Texas law applies. Even if Lively were able to convince the court that this California fee shifting statute is substantive, California law would still not apply. Texas substantive law applies to Lively's request for attorney's fees and costs. Lively is correct that a federal court sitting in diversity applies the choice of law rules of the forum state. And as she further acknowledges, Texas follows the most significant relationship test of the restatement of conflict of laws, which considers factors relevant to the facts of the suit as well as policies underlying application of the law of potentially interested states. Lively relies on a California fee-shifting statute awarding fees to a defendant who prevails in a defamation action following a determination that the defendant's statements were privileged under California law, not available under Texas law. Lively ignores the laws of the state of New York, where she is domiciled, and where she filed her own lawsuit. But New York also does not have a similar fee-shifting statute. So there is no conflict between the laws of Texas and New York, but both states' laws conflict with the laws of California. As here, when the laws of potentially interested states conflict, Texas choice of law principles require courts consider certain factors including relevant policies of the forum state and other interested parties, certainty, predictability, and uniformity of result, and the court's ease in determining and applying the law. For tort claims, courts consider these factors in connection with the parties' relevant contacts, including 1. Where the injury occurred, 2. The tortious conduct occurred, 3. The parties are at home, and 4. The relationship centers. Lively barely addresses these contacts and policies before reaching the answer she wants, that California law applies. But the contacts and policies weigh heavily toward the application of either Texas or New York law, which are not in conflict. Where the injury occurred. The greatest injuries to Wallace and Street occurred in Texas, the state where both are at home. Wallace is a Texas domiciliary. Street is a Texas corporation, formerly a California corporation, headquartered in Texas since long before the complained of statements in this case. Lively contends that this contact points toward California because Street was once a California corporation, but ignores Wallace's domicile in Texas and Street's home in Texas, where it had its headquarters at all relevant times and still does. Texas has an overriding state interest in protecting state residents from malicious libels. Where the tortious conduct occurred. Here, Lively miscasts the underlying record entirely, claiming that the basis of plaintiff's defamation claim was Ms. Lively's filing of the CRD complaint in California. No, it wasn't. It was the New York Times. But what plaintiffs complain about is Lively's publication of the CRD complaint to news media in New York and elsewhere, including, in particular, as Lively's motion recognizes, the New York Times. Plaintiffs also complain about Lively's actions in Austin, Texas, and Waco, Texas. And because Lively is domiciled in New York, much of her tortious conduct likely originated from there, not California. Both Texas and New York have strong interests in regulating conduct within their borders. Where the parties are at home. Lively is at home in New York. Wallace is at home in Texas. Street is at home in Texas. And, before it reincorporated in Texas, was also previously at home in California. This factor weighs towards Texas or New York law. Where the relationship centers. The parties do not have a relationship. Wallace never met Lively. He still has not. Certainly had never sexually harassed her and was never on the set of the film where Lively claimed the alleged harassment occurred. Lively does not appear to dispute this. Instead, Lively attempts to create a relationship that centers in California because that's where the CRD complaint was filed. I mean, when you put it like this, it just sounds so fucking ridiculous. It exposes how ridiculous this is. But again, plaintiff's complaint is not about the filing of the CRD complaint, because it's important to remember that would have been confidential and private. It is not about the filing of the CRD complaint. It is about Lively's subsequent efforts to publicise the CRD complaint to news media, particularly the New York Times, and the resulting harm to plaintiffs' reputations in Texas. Because there is no relationship between the parties, this contact is neutral, or at best points to New York, where Lively is domiciled, or Texas, where plaintiffs are at home, neither of which conflict. Texas law applies. No factor weighs towards the application of California law. At least 3, and potentially all 4 contacts and relevant state policies weigh towards the application of either Texas or New York law. Further, applying Texas or New York law, which are not in conflict and which are the states where the parties are at home, advances the principle of providing certainty, predictability, and uniformity of result. And it will be easier for the court to determine and apply Texas or New York law, particularly because the California law Lively relies on has not yet been interpreted by a published decision in either state or federal court. Because Texas law and New York law are not in conflict on this issue, the law of the forum state, Texas, applies. Lively's fallback reliance on the general choice of law principles in Section 6 is unfounded. These principles are not considered in a vacuum, but through the relevant contacts, as here under Section 145. Whatever interest California may have in providing a strong remedy to disincentivize retaliatory litigation hardly applies to litigation in Texas by Texas plaintiffs against a New York defendant on the basis of whose complaint of conduct is the publication of defamatory allegations to New York media. Nor could California's general interest outweigh the strong interest of Texas in protecting its residents from defamation, or New York in regulating the conduct of its citizens. Both states' interests far outweigh any California interest, and since Texas and New York are not in conflict, Texas law applies. I will read this, but no, actually. Even California recognizes that the place of the wrong has the predominant interest in regulating the conduct, which is the state where the last event necessary to make the actor liable occurred. Here, publication to news media in New York was the last event necessary to make Lively liable for defamation. So even California would recognize New York's much stronger interest in regulating Lively's conduct, and New York law is not in conflict with Texas law. Okay. Lively is not entitled to attorney's fees and costs under Texas law. Texas follows the American rule on damages, and attorney's fees are not recoverable unless specifically provided for by statute. Lively agrees that there is no such fee-shifting law that would apply. Because Texas law applies, and there is no provision shifting attorney's fees and costs to Lively under Texas law, Lively is not entitled to her attorney's fees and costs. Even if California law applied, Lively cannot obtain attorney's fees and costs because of the procedural posture she created. But even assuming now that Lively convinces the court that the fee-shifting statute is substantive and California law applies, Lively does not qualify for fee-shifting because there has been no determination that her communications were privileged. To overcome this, Lively again asks the court to make a finding it declined to make when granting Lively's motion to dismiss, that her communications were privileged under Section 47.1a. But she cannot overcome the procedural limitations of where she finds herself. The court did not and cannot decide the merits of Lively's privileged defense when it decided her motion to dismiss for lack of personal jurisdiction. When ruling on a motion to dismiss for lack of personal jurisdiction, courts are limited to making jurisdictional findings of fact. That is exactly what the court did in its order on Lively's motion to dismiss, declining to address any other asserted basis for dismissal. So the court is powerless to adjudicate Lively's claim that her communications were privileged under Section 47.1a. Indeed, it did not. Lively gets this backwards. Courts that lack personal jurisdiction over a defendant cannot and do not determine the merits of whether a defendant engaged in privileged conduct. They do not make any decisions on the merits for a defendant, like Lively, who is trying to dismiss the case. Instead, courts in this circuit go no further than to resolve all factual conflicts in favour of the party seeking to invoke the court's jurisdiction. In other words, the court could at most resolve plaintiff's well-pleaded allegations that Lively acted with malice, not whether Lively's communications were privileged. That's a good point. Lively's contention otherwise is not, as she says, inescapable as a logical matter. It entirely contradicts binding and logical precedent. Plaintiff's allegations that Lively acted with malice defeat her conclusion that her communications were privileged. Even if the court could reach the merits of Lively's asserted defence, she cannot overcome plaintiff's allegations of malice. Lively relies on California Civil Code Section 47.1b, which states in relevant part, a prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. The statute defines a privileged communication as a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. When interpreting the statute, we begin with the text. In this case, the text contains at least 5 requirements. 1. A prevailing defendant. 2. In any defamation action. 3. Brought against that defendant. 4. For making a communication. 5. That is privileged under this section. No doubt this is 2. A defamation action. 3. Brought against Lively as a defendant. 4. For making one or more communications. But Lively is not 1. A prevailing defendant, nor has there been any determination that 5. Her communications were privileged under Section 47. I think that's supposed to be 47.1. Because these 2 elements are missing, even under California law, Lively cannot obtain attorney's fees and costs. For 1, plaintiffs allege that Lively acted with malice, including by listing Wallace as a defendant in the draft complaint alleging sexual harassment and retaliation, and then disseminating it to the media, which is all that is required at the motion to dismiss stage. Lively's favoured case on the Section 47, which she believes must apply to Section 47.1 as well, makes plaintiff's point. Even if Lively is right that the malice requirement is triggered, where the communications privilege status is disclosed by complainant's allegations, she disregards the Supreme Court of California's conclusion in Capellas that a plaintiff defeats the qualified privilege by pleading malice at the motion to dismiss stage, as plaintiffs did here. The Capellas court reversed a dismissal at the demurrer stage, California's dispositive motion at the pleading stage, on this basis where a complaint alleged that a defendant made an otherwise privileged communication, well knowing that it was false or with reckless disregard whether it was false or not, because this court has consistently held that allegations of malice similar to those set forth in the complaint defeated qualified privilege of Section 47. No other outcome is proper here at the pleading stage. Lively alleges a communication is privileged, and plaintiffs sufficiently alleged malice to defeat the qualified privilege. If this procedural California law applies, and again, it does not, the motion fails for this reason alone. Even if more were required at this stage, it is not. Lively's statements were not privileged under Section 47.1a, as plaintiffs explained in their response to Lively's motion to dismiss. Lively does not deny that Wallace has never met her, much less harassed her, nor ever appeared on set of the film where Lively alleges the harassment took place, and she does not refute that her ambiguous group pleading left a reasonable reader with the impression that all causes of actions were attributable to all defendants, including plaintiffs. Regardless of whether Lively had a reasonable basis to make a CRD complaint about other parties, and regardless of whether any privilege extended to public disclosure of the private CRD and draft complaints about those parties, it did not. Lively had no reasonable basis to lump Wallace, much less Street, into those complaints. Lively's ambiguous drafting and subsequent publication to the media was a choice. Thank you. That's the crux of it. It was a choice. So the ambiguous drafting and subsequent publication to the media was a choice, and it shows malice towards plaintiffs. It does not support, as Lively contends, a reasonable basis to implicate a person Lively has never met in sexual harassment charges. California's privilege, meant to protect victims at the hands of their abusers, does not attach to something this offensive. Thank you. This is actually like one of the best arguments. This is one of the best arguments. Yeah, absolutely. Further, the privilege does not apply to defamatory statements extending beyond sexual harassment claims, as the complained of statements did. Though the court cannot reach the merits of Lively's defense at this stage, even on the merits, Lively's claim of privilege fails. The motion must be denied. Lively is not a prevailing defendant. Under any plausible reading of Section 47.1b, Lively is not a prevailing defendant. As the Supreme Court has explained in interpreting similar prevailing party language, enduring judicial relief that constitutes a material alteration of the legal relationship of the parties. As to the specific prevailing defendant language used in California Civil Code Section 47.1b, just 3 cases have cited this language, and 2 relate to Lively's own filings in the New York case. Neither of the New York decisions interpret the meaning of prevailing defendant. The other, an unpublished decision from the Central District of California, recently interpreted the prevailing defendant language and determined that when a court does not specifically grant relief under Section 47.1, there is no basis for an award of fees or damages. Ignoring this, Lively claims that because Section 47.1 is similar to California's anti-SLAPP laws, and one California decision has decided that fee shifting is permissible for defendants who successfully defend under California's anti-SLAPP laws, even on jurisdictional grounds, this court should just import the anti-SLAPP rules. It's a footnote. This approach would conflict with the Fifth Circuit's determination that similar anti-SLAPP laws do not apply in federal court. Okay. But that California decision does not bind this court, and it runs headlong into binding authority that prevailing requires enduring judicial relief that constitutes a material alteration of the legal relationship of the parties. A decision that this court lacks personal jurisdiction makes no such material alteration. Among other options, plaintiffs could prevail on their pending appeal or sue Lively in another jurisdiction where the court has personal jurisdiction and receive a determination on the merits. The court's decision only addresses where plaintiffs may sue Lively, not whether they can. The parties' legal relationship has not changed. Lively's other cited authority further undermines her arguments. The Supreme Court in s.47.1 recognized that in addition to a decision on the merits, a finding that a plaintiff's claims were meritless could support prevailing party status. There was no such decision here. And for Star Farm Inc. stands for the same unremarkable proposition. And then San Diego County Credit Union adds the obvious explanation that any determination that judicially precludes from refiling the claim against the defendant in federal court is sufficient to trigger prevailing party status. And in my video, I did notice that a few people did not think that Wayfarer, that Lively was a prevailing party in her action where she was dismissed from Wayfarer's claim. I do think she was, and that is because the claims were dismissed with prejudice, and Wayfarer cannot refile them, and that's the difference between the Wayfarer lawsuit and Lively being dismissed from that, and here where she was dismissed, but it was without prejudice, so Wallace can file somewhere else. It's not the end. As explained above, plaintiffs may file the same claims against Lively in another court. In any event, none of the cases she cites awarded fees, despite remarkably being cited for the proposition that courts routinely award fees. Finally, Lively's narrow reading of section 47.1a's text completely misses the mark. The law in this court and elsewhere tells us that statutory interpretation requires consideration of the statute in its entirety. Words and statutory phrases cannot be read in isolation. Rejects these canons of statutory interpretation and wholly ignores the immediately following phrase that the defendant must have prevailed for making a communication that is privileged. Prevailing defendant cannot be read without consideration of the statute as a whole, and as explained above, there has been no determination that plaintiff's action was based on a privileged communication. This is so good. Lively is not entitled to costs under Rule 54. For similar reasons, Lively cannot obtain court costs as a prevailing party under Rule 54. Lively does not claim to seek costs as a prevailing party under Rule 54d1. To the extent she raises the argument in her reply, she has waived it. But even if such arguments were considered sua sponte, Lively is not a prevailing party under Rule 54. And when they say sua sponte, what they mean is if the judge decides on his own sort of volition, well, I'm going to deny the fees under section 47.1, but I will award under Rule 54. They're saying, look, don't do that, judge, because she actually waived her right to fees under Rule 54, if it did exist. Again, the Supreme Court has routinely found that to prevail requires that the court enter enduring judicial relief that constitutes a material alteration of the legal relationship of the parties, which could include a finding that plaintiff's claims were meritless. Again, there has been no such enduring judicial relief here. Plaintiffs could, among other options, sue Lively elsewhere for the same claims. Thus, Lively is not a prevailing party under Rule 54d1 and is not entitled to an award of costs. Conclusion. For all her protests about litigating in Texas, Lively just can't seem to quit us. I love it. Her latest mess with Texas finds no support in choice of law principles. Fifth Circuit law about how facts are resolved or not in the procedural posture she created, nor even in the plain text of the California statute she invokes for relief. Oh my god. This is quite brutal. Though we can't blame her for choosing Texas once again, it doesn't take a crystal ball to see that the motion should be denied. Charles Babcock, the legend. That was absolutely awesome. It was a much stronger response than the one that is available to Wayfarer. I think she's going to struggle to get her Section 47.1 fees here in Texas. I do, because there was a lot of things. It's very different scenario to Wayfarer, and I might do a video doing a bit of a compare and contrast, given that I did the video earlier on some of the issues and elements that would apply in the Wayfarer case. I talked a little bit about Jed Wallace and what would happen over here, given this motion is pending here too. But it is a different scenario, which might warrant maybe a 20-minute video or something with my PowerPoint slides kind of laying out, this is a situation in Wayfarer, but this is a situation in Wallace, and pointing out the differences and what that difference can mean. Like, I think Jed Wallace has a far stronger grounds to have this motion denied than Wayfarer. I still don't think the judge is going to even grant it in the Wayfarer action, but I would be incredibly shook if this Texan judge grants it. So, but we'll see. Lively gets to reply in a week, so I'll keep an eye out for that. All right, guys, have a great one. I hope you had as much fun with that as I did.